Today on The Art of Adjusting will be laissez les bon temps rouler with Todd Musgrave. I'm Chantal Roberts, and I'm joined by Todd, who is a partner at Musgrave, McLachlan, I guess is how you pronounce that, and Penn. We don't really care about them, do we? Todd, thanks for being here.
You're welcome. Thanks for having me.
Okay, so Todd, it is Mardi Gras, and I asked you here to talk about Louisiana law, which is different than the other 49 states. First, is it a law in Louisiana that one must celebrate Mardi Gras? And what are the penalties if you're caught not throwing beads at people?
50 lashes. Yes, it is a law, but this year it is not a law. In fact, this year, if you celebrate Mardi Gras because of COVID, you would end up breaking the law and going to jail. So because of, what we've all been dealing with for the last year, and because New Orleans Mardi Gras, I've heard yesterday was a hot spot when it all started back in March. And they said, and I don't know how they know, but they said one person was responsible for infecting 50,000 people in the New Orleans area. And this person was from Houston. So because of all that, and our mayor's been pretty strict the whole time with COVID, Mardi Gras is canceled.
Hmm.
There are houses on St. Charles Avenue that have dressed themselves up as floats so that people can get by this with a little bit of Mardi Gras. But bars closed today
Hmm.
through Wednesday, and they're fully closed. And restaurants I think they stop serving at 11, and there's no to-go cups. And so there's a lot of police out, and I'm sure someone's going to have to try to have a party. But as far as breaking the law, it would be by participating in Mardi Gras this year.
Wow, that is pretty serious. Now, I hadn't heard that they were being that serious about that. But getting on a serious note, now Louisiana is of course different than the states that surround it, and I know that this comes from being a French territory. So, can you tell us a little bit about what is the law in Louisiana?
Yeah, I mean, we are a little bit different pretty much in everything we do, and the law included. And it's a Napoleonic code. So the way we work is there's a code. There's actually the Civil Code of Procedure and the Civil Code, and then I guess I would call revised statutes that are all codified. And if you're doing it the right way, if you have a problem, you look to the code first. You look to what the code says. It's sort of the law of the state, and you start with that code article, and then the cases, unlike the other states that use the cases as their precedent, the cases serve as persuasive argument to support a certain code article.
So, a persuasive argument is another word for a precedent, I guess.
It is because the cases basically give factual scenarios or examples of how that code article was used and applied. So a judge can always say, I read this code article this way, and it says enough to me that it's clear that I can decide this issue on the code article. But yeah, ever since I've been doing this for 25 years, cases have always been used to support your argument because they give examples of other cases that have used that code article to support your decision. Now, it starts with a case is probably, or it is more persuasive if it's from your particular circuit that you're arguing in. If it's from a surrounding circuit, there's 5 in the state of Louisiana, it's a little bit less persuasive. And look, if you have a rogue issue, you can certainly go out of state and drop in something from an out of state court. That doesn't, it's not that it doesn't sit well. Like in Louisiana, it's very territorial. So some judges may be like, I don't care what anyone says in any other state, period. But if it's the only case ever addressing the issue, it's never a bad idea. Judges don't have to follow it, but it's never a bad idea to add it in and just use it to support trying to win whatever you've got before the judge.
Yeah, because I mean that is something that really I've never really understood since the law is codified. I've not understood how president plays a part in it, because I'm used to judges saying, well, Montana thinks this, even though I'm in Oklahoma, and that makes a lot of sense. So I'm going to do what Montana says. So basically, a judge in Louisiana can go, okay, well, this is what the law is, but this is the way that I'm interpreting it, if I'm understanding you correctly.
Yeah, I mean, look, lawyers find argument in the shortest and simplest sentence that you could make. There's always somebody that's going to say, no, it doesn't quite say that, it says something else. So the code article, for example, on negligence, that may be very straightforward, it's not very lengthy. And Negligence probably isn't a good example, but they don't seem to be that much, there doesn't seem to be that much confusion in the language of some code articles. Yet attorneys will always parse it out, find a word that doesn't fit, or find a word that they can use to argue against. And so I think, I haven't practiced in any other states. I mean, we have lawyers here, 4 of them that are in Mississippi. I'm not, but I asked them about the difference, and they're like, there's really not much. I mean,
Yeah.
if you're teaching a class, yeah, there's a difference, but in the way I've always argued a motion or an exception in court is pretty much by, most of my argument is using case law to support where I'm going,
Mhm.
because there usually is case law on a particular issue. So at its purest form, it's supposed to be the code article, and that probably does prevail. If there's a be all end all stop, it's the code article. But our briefs are always full of cases that support that, I guess, usage of that code article and how it applied to a situation that we feel, suits what we're looking for, looking to get. So we'll put those on our briefs.
Yeah, it's funny that you mentioned that attorneys will argue about anything, because I always tease the attorney saying like, yeah, you could say good morning and an attorney will be like, what's good about it? What do you define morning? You don't really care if it's a good morning or not, and I know how y'all are.
Yeah, I mean, I don't know if we're wired like that from the beginning or we get like that, but I mean, arguing over things is just second nature sometimes.
Yeah, yeah. So does Louisiana, since it's codified, does it find it hard to keep up with some of the changing times? Things change so rapidly. For example, I'm thinking about marijuana and cannabis claims, because that's kind of like my niche. And just over the past 2 years, a lot of the definitions have changed. So if the legislature is making the laws, wouldn't they have to always be like rewriting the laws?
To some extent, I mean, it's always a work, right? It's always a work in progress. It just is. And every year they've got certain bills that get put up and things that get passed. And yeah, the law is tweaked from time to time. In fact, the 2 things that I can think of is procedurally, our summary judgment standard has probably been tweaked 2 or 3 times in the last 10 years, I think. Not a lot, but different tweaks, burdens of proof, timing, time of filing certain things like replies and briefs, and certain days before the trial that the summary judgment has to be heard. So they're always revisiting things. The thing that comes to mind that's had the biggest impact in a long time, I think, is a law that the legislature passed that began at the beginning of this year. And it finally dealt with a lot of the, in terms of the insurance market, a lot of the things that were always topics and always problems. That being a couple of things that they did was, we used to always have a $50,000 jury threshold, meaning if a plaintiff's attorney ever said, I'm going to stipulate that this case is below $50,000, he eliminated the defendant's ability to have a jury. It always went before a judge.
Right.
And judge trials are better, and to some extent, because they're streamlined and they're easier and they're, less formal. But on the other hand, sometimes defendants representing out-of-state insurance companies don't fare as well as maybe a Louisiana citizen who's been injured. So that $50,000 threshold was always a bear if the plaintiff stipulated, because it made you have to think a little bit harder about the value of the case. That finally has dropped down to $10,000. And $10,000 in a lot of these personal injury cases can be had at the drop of a hat. I mean, you go to the emergency room and you go to a month of treatment, and with your general damages and your medical records,
Right.
arguably you're starting to push that number. So I think, well, I know it's going to cause a lot of more attorneys, plaintiff attorneys, to deal with a jury threshold that's a lot less than 50,000. It's down to 10. How that impacts, the docket and clogs it up, and settlements versus trials, I don't know. But the defense side of the insurance industry has always felt that dropping that down would benefit rates and take away the $50,000 threshold. And so they find that seems to be a benefit to the insurance side. A couple other things they moved around in beginning in 2021, collateral source. No longer is collateral source available to the extent that it was. You don't, that helps in certainly the value of the case and what you would have to pay at judgment or verdict or even in settlement. One of the other things is seatbelts. Seatbelts before 2021, if you didn't wear one and you got in a car accident and you were injured, you could never use a seatbelt as a defendant for comparative fault. Now you can. How much a jury or a judge thinks that wearing the seatbelt would have changed things, I don't know, but you can at least make the argument that not wearing your seatbelt is fault on the injured party in the car. And the other one, and perhaps, I mean, this one might even be the top of the list in changes, is they've eliminated under most circumstances direct action. Louisiana was always the state, and I think Wisconsin is the other one, where they would always name, the plaintiffs would always name the insurance carrier as the defendant. Sorry. And the insurance company was named as the defendant, and they would do that because to let the jury know that there's insurance out there, so that plaintiffs felt that if a jury knew there was insurance, they might be more likely to give an award or a higher award, knowing that the defendant wasn't going to be personally responsible. They also, with direct action before 2021, if you had a coverage issue, and if you wanted to reserve rights, you had to hire two attorneys, because both the insurance company and the and the defendant were parties. So you had to have an attorney for each one of them, which basically doubled the cost for the insurance carrier. So going forward, those are four big things in this law that was just changed that is going to change the landscape one way or the other of what I do, litigation, personal injury defense litigation. We'll see how much.
Cool. Well, you've answered some of the questions too that I had coming up. Is the vlog here that we're doing is for lay people to understand kind of like some of the things that adjusters have to know in order to adjust claims, and for young or new adjusters to get a little bit of spot training and important topics. And you've kind of talked about how the codified Louisiana laws have affected insurance in that way. Really interesting to know about the direct action thing, because I always thought it was just Louisiana that had direct action. And I happen to be writing a book right now for claims adjusters, and found that there are a couple of different states that have direct action, which I never knew about. So you said that it's no longer there for us to worry about for Louisiana. Is that right?
Limited.
Okay.
Like if you had a claim, just as an example, obviously you could name the insurance carrier for uninsured motorists when I say
Right.
But they've taken it out of how I see it most used.
Right, with a third party administrator or with a third party claimant or whatever. Yeah. Okay, cool. Okay, so one thing that I think is really important for people to know about Louisiana is that there are a few things that are interpreted differently. A proof of loss, for example, that could be a lawsuit. We've always told our adjusters that it could be a number written on the back of a bar napkin. What should an adjuster do if something like that comes to his or her desk?
I mean, with regard to a proof of loss, you're right. I mean, one of the things, look, we've seen it. We had an uptick of litigation back in 2005 and beyond from Katrina. And right now, Louisiana got nice and pummeled this summer by a few hurricanes. Delta and Laura are out west of me in New Orleans and Lake Charles. The lawsuits and the claims have obviously been coming in hot and heavy. We're handling a bunch of those. And one of the things that we always run across is this, proof of claim and proof of loss. And what is satisfactory proof of loss? That's sort of the term in Louisiana. And sometimes people, because I don't know really how other states work it, but they want a form filled out to hit the requirement or the satisfaction of this proof of loss. And we have to tell them that's, proof of loss can come in many different forms. And it's when you see the property because it was there yesterday and it's gone today, or you get pictures, or you've had an opportunity to go adjust it or scope it or do something. But that's when the proof of loss arguably occurs, and it's not when a certain form is filled out. So if you're the adjuster handling one of those claims, I would lean heavily on my attorney to give me the right advice. And I would not say, well, And the reason I say that is because our penalty statutes are a lot of them are based on accounting principles. So, and they start at satisfactory proof of loss. One is 30 days, one is 60 days. So if an insured or an insured's attorney feels like you were out and you adjusted or scoped the property on X day, they're going to start their stopwatch and say, well, now I just need to count as for 30 days or 60 days. And you wouldn't want to be the adjuster or the examiner saying, well, no, my time for 30 and 60 doesn't start until I get this signed piece of paper back. You would find yourself in a world of bad faith and hurt, and it would all just unwind. So, you know, like Louisiana is a lot of who you know and not what you know. And there's a lot of, it's not huge, and attorneys see each other often in cases. It may not be the same year, but it may be every 5 years or something like that. And so, you know, I think it's always good to also rely on your attorney. Like, the attorney should know the law and how to handle a case and how to properly defend it and do research and so on and so forth. But there's a whole nother intangible to your attorney that can provide you massive benefit, even possibly more than my first list of things, that being who you're dealing with, what judge you're in front of if lawsuit's been filed, what's the temperature of the community when they've been wiped out by a storm, as opposed to one business that maybe had a fire start for some unknown reason. You've got a big sympathetic where people rally and they kind of group together. And, you know, even though they may say, this is a little bit sketchy or whatever, there's a sort of a community momentum. And you just gotta get from your attorney, if you don't know, or if you're the examiner that's been there, then you certainly know. But it's never bad to also get that extra sort of ingredient of, you know, in, for example, a hurricane claim, you know, what's going on, who are we in front of, and what kind of influence does this insured or this attorney have on this claim? Because it all matters.
Yeah. Yeah, it does. I would totally agree with that, because New Orleans happens to be like what they would call like a big, small town. But I think, for full disclosure, we've known each other for about 18 years now. So I have to ask, what have y'all done in Louisiana to assure the weather gods that you won't have 5 hurricanes this summer?
Well, I guess I would say I'd have to not do what I did last year to get the hurricanes. And I guess, well, one man's trash is another man's treasure. Now, New Orleans did get hit with Zeta. We were in the cone, I think, I don't know, last year of 9 different storms, and we finally got hit with Zeta in October. But, you know, I've lived through Katrina.
Mhm.
It sucked. I lost the house. I had to rebuild. I had Chinese drywall. I had to pull that out. It was completely miserable. So hurricanes are devastating. They wipe out communities, and some respond and some don't. So they're a bad thing for sure, for, you know, especially when you get hit multiple times in the same summer. So, you know, there's enough people that do, as you said, voodoo or whatever chants, go to, you know, church and hope that we don't get hurricanes. But
Like, do something else. Last I heard was you know, do some voodoo or light some candles or whatever, when I was just being flippant about all the hurricanes that y'all have done. And I know from, you know, the adjusting point of view, it's really hard to adjust to claims back to back, because we handled, you know, Katrina and what was that, Laura, afterwards, that hit.
Laura was this year, but there have been a few. Gustav, I think, was one, and
Yep.
and there have been a
It's
few.
hard.
Nothing as widespread and devastating. But look, if you're the one that got hit,
Yeah.
you're the one that says, you know, it affected me and ruined everything. It destroyed everything I had. I get it. Not trying to be, you know,
Mhm.
unsympathetic about it, but this year was, you know, I think the worst year since back when we had Rita and Katrina in
Rita,
05.
that was what it was. Yeah, Rita. Yeah, Katrina and Rita. But yeah, no, Aaron is working a lot of those hurricane claims. So I'm still very familiar with what's going on. Todd, I'm not going to keep you any longer. I know that you're busy. I can see that you've got a busy office right there behind you. And is there anything else that you would like to plug? Anything that you would like to let people know about?
No, I mean, I appreciate talking to you, and I'm happy to give you my thoughts on the topics or the questions that you asked. I'm in New Orleans. I don't know if there are any other questions you have or anyone has with regard to first party or third party or the change in the law. You can always look me up. I mean, our website is mmpfirm.com, which is Mary Paul
Great.
FIRM.com.
And you can give your email address too, and that way people can reach out to you. If you
Okay,
want them to, maybe not, I don't
well, I mean, sure, I'll take it.
know.
It's my initials, so it's rtm@mmpfirm.com.
Okay, great. Yeah, Todd, I really appreciate you helping me on this, and it was so good to talk to you again.
You too. No
Thanks.
sweat. Thank you.
This week I discussed Louisiana law with Todd Musgrave. Every claim is different, and every insurer has different protocols for handling losses. However, this being in the litigated world we're in, see below for some legalese. Few claims go to a jury trial, and picking the expert who has been deposed the most or who has gone to trial the most may not be the correct expert. Failing to have a second set of eyes on a claim in order to save some expenses isn't always the best way to resolve a loss. As an expert witness and a former claims adjuster, I am sharing my experiences in the art of adjusting. Thank you for listening. I appreciate your time.